Hey everybody, and welcome to this video. My name is Chris Harris. I'm a certified financial planner, and today we're going to be talking about wills versus trusts and which one actually protects your family. Which one do you actually need? Do you need one? Do you need both? So we're going to review that and hopefully shed a little bit of light onto the importance of estate planning and how you can actually set it up to protect your family and your assets. As a disclaimer, this is for informational and educational purposes only, and it is not legal advice. You should consult your own estate lawyer or professional for your individual and specific needs. Okay, so I get this question a lot. So folks want to know, well, do I need a trust or do I need a will? Well, let's dive into this, and we're going to go over the important estate tax documents that you should have, right? And so you've probably heard of some of these before, but we're just going to review them, just kind of make sure that we understand the terminology, what they are, what they do, and why it's important to have one. So a last will and testament. So this is what we think of when we think of a will, obviously a last will. So this is how we want our assets distributed, okay? After we pass away, we want our beneficiaries to get them. You know, whatever that is, our house or a car or whatever, we want to put that into our will. Generally, they're a simple document, signed, and, you know, not a whole lot to it, but, you know, it can be pretty simple. There's different types of wills. We're not going to go into that. But just for simplicity's sake, this is just how we want our assets to be distributed. Then we have a durable power of attorney. So this is for our financial. We have our financial durable power of attorney. We can also have a medical power of attorney. So FPA or MPA, maybe it's a different acronym for them, but our financial durable power of attorney is somebody that can pay for bills, they can pay off debts, they can control the financial situation if we are incapacitated, okay? This durable part here, this durable means that it lasts after the person giving the powers away is incapacitated. So for example, if John became incapacitated, then his son, if he made his son the durable power of attorney, then John's son would be able to control the financial affairs of John's financial situation while he's incapacitated. Maybe that's paying bills, paying off debts, accessing accounts. But this durability part goes away once they pass away. So once John, in our example, passes away, then this power goes away. Goes away at death. Okay, so this goes away at death. You can have different types of durable powers of attorney. So you can have an immediate, or you can have a springing. Okay, so immediate is once you sign that document, that individual has immediate access to your financial situation, right? So they can pay bills, they can do what they need, they can access your accounts, things like that. So they're going to have that ability. Springing is if the durable power of attorney will kick in once an event happens. So for example, say you do become incapacitated, then that springing power will spring into place, and then that individual then have power once that situation has come into place, like the incapacitation. So it's important that you understand both of these and which one you want for durable power of attorney. Medical directive. So this is the medical piece, as it says in the name. So this is going to actually be made up of a few documents here, but the medical directive is somebody has the authority over you to make medical decisions. So if you're in the doctor's or in surgery and the doctor has a question, you can make a decision on behalf of yourself while you're incapacitated. So they can make that decision for you, and it's also derived from this living will. So you're going to have in the living will is going to be, let me erase that. You're going to have a living will that is going to dictate what happens to you if you are incapacitated. So for example, if you are on life support, this will be a directive to say, hey, I don't want to be on life support for, more than 5 days or whatever it is, or do not resuscitate, or, that's going to be baked into this living will on how you want to proceed medically, okay? Or if something was to happen to you, this will be within this medical directive portion. So the medical directive is giving authority to a person to make decisions on your behalf medically, right? The living will is going to stipulate how you want to be handled in certain medical situations, okay? The beneficiary review here this is also very important. So you want to review your beneficiaries continually, right? For your brokerage accounts, your IRAs, your 401ks, things like that. Make sure your beneficiaries are put in place. And we stress that all the time to clients to make sure that somebody is labeled as a beneficiary, because if they're not, then it becomes a real problem. It becomes a real problem for those beneficiaries or the beneficiaries you wanted to take over that asset, for them to actually get the asset after you've passed away. So it's just one of those things where it's more administrative work, but it's very important to make sure that that's labeled and reviewed and refreshed at least annually. And so as we look at the last will, we do something called probate after you pass away. Okay, so we talked about during life. During life, you create these documents, you have the documents, and like we said, these directives, these power of attorneys, these all go away once you pass away. Okay, so these go away, you pass away, and then from there, your estate will go to probate if you just had a will. So if you had a will that said, hey, I want my house to go to my kid, well, that's great, but it's got to go through probate. And we've all heard probate. It's kind of a scary word, but doesn't have to be. So here we go. So we're going to learn about probate just real quick. It's orderly distribution of property. It's court supervision, can be costly, and it's public, which means that there's claims by creditors. So creditors can actually get to those assets, I guess, more easily than if it was in a trust. And we're going to talk about trust here in a second. But this is what probate is. And then if everything is in order, then it will then transfer to the beneficiaries. But it may not as well. So especially when you get into complex family relationships where you have a spouse from another marriage and things like that, then this can get a little bit more sticky. But this is why it's very important to understand the difference between a will and a trust, and which one do you need. Okay. All right. So let's dive into trust. So this is we're going to talk about trust real quick. There's different types of trust. We're not going to go over all of them. There's so many of them, but we're going to go over the main ones. So we have a revocable trust, and an irrevocable trust. A revocable trust is a trust that can be modified and changed during life. Once the grantor, we're going to talk about the kind of the names that go with these, but the grantor, or the creator of the trust, once they pass away, it becomes irrevocable. You can set up an irrevocable during life. So this can be modified during life. And this is irrevocable will be unchanged during life. So it takes a lot to unchange that. Be really messy. So if you decide you want to create an irrevocable trust, then basically what you're putting into that trust is going to be irrevocable, meaning it can't be taken back. And a lot of times, folks will use irrevocable trusts to do sorts of, so we have like CRATs, we have QPT, QPERTs, We have grats. We have, there's so many of them. So we have charitable remainder annuity trusts. We have so there's different types of irrevocable trusts. And the reason why folks do this is you get in more complex estate planning is to shield their estate from estate taxes or gift taxes or things like that. So there's tax benefits to doing that to remove assets from the gross estate. And we're not going to get into that now, but just so we know the differences between revocable, irrevocable. There's testamentary trusts, which we're not going to get into, but there's just a lot of different types of trusts. So if you have a trust, no probate. So it goes to the beneficiaries. It's pretty clean and simple, right? So you have the trust documents, and they're going to read who the beneficiaries are. It's going to go to those beneficiaries after the passing. It's more private, reduced risk of contest. It still can have some contest, but there's some reduced risk there because it is private. It avoids ancillary probate, which is if you have property in different states. If you have a trust, then it will be able to label those properties without having to go through each state and their probate system. So more kind of in depth on a trust. So we have the grantor, the settlor, the creator. These are all the same names for whoever establishes the trust, who is going to be the grantor, if you will, of the trust. So they're going to have property. So this could be property or any assets really. So you could have securities, whatever. This will go into the trust. You'll have a trustee. The trustee is going to be a fiduciary, meaning they are going to have to put the trust in. It's going to have to be the best interest of the trust, whatever they decide, right? And it's going to be in the best interest of the beneficiaries. So beneficiaries. So they're going to have that fiduciary standard for the beneficiaries. And whatever within this trust, you can have income coming to the beneficiaries for term or life. So there's certain income streams you can have. And then it will go directly to the beneficiaries, whereas the will has no sort of protection here. There's no protection, okay? There's no trustee. There's no protection that, you know, it will flow through to the beneficiaries or even income distributions, anything like that. So very high level, but this is basically how a trust works. You're going to have the grantor, the beneficiaries, the trustees, and that's how it's going to be. The property will be distributed by these trustees to the beneficiaries. The trustees can be the beneficiaries. They could also be, you know, they could receive income. So there's a lot of different ways on how these trusts are set up. But just as a kind of an overview, this is a very basic, high-level view of how the trust is set up. So let's run through a quick example just so we understand. So if we had John, as I mentioned before, oh, that's not how you spell John. It's terrible. So we have John and Jane. So they're a married couple. Let's just say they're older, so they could be in their, 70s or 80s. And then we have 2 kids. These are adult kids, and let's say they're in their, 40s. Okay. And again, this is a very simplistic example, but I didn't want to make it too complex just so that we understand. So let's just say they have a house. They have, $100,000 in their bank. They have $500,000 in their investment account. They have, $1.5 million in their 401k. And then they have, let's just say they have some cars, some classic cars or something worth, $200K. So if they had a will and they said, you know what, we have a will and we want that to go to kid 1, 50%, and kid 2, 50%. What's going to happen to these? Okay. On this 401k, they labeled their beneficiary as kid 1, kid 2. So what would happen with the will? So the $100,000 in the bank account, this would go through probate. The $500,000 in the investment account would go to probate. The $1.5 million in the 401k would go to each kid. So with 401ks, these do not need to be in a trust because they are already a trust themselves. So you just need to make sure. That's why it's so important to have these beneficiaries labeled. Cars, unless it was titled differently, it would go to probate. Okay. Now, what would happen if we're in a trust? Okay, so trust. Oh, that is terrible. So a trust. They want kid 1 to get 50. Same thing, right? Kid 2 to get 50%. What would happen? So now this $100,000 would transfer. So 50-50, right? 50-50. The 500K would be 250, 250. The 401k transfer the same. The car, sell it, and they would each get 100K. Okay? So this would flow directly to the kids, and those assets would be created, or they would be labeled within the trust. So, oh, and I forgot the house too. We don't want to forget the house. So the house would go through the same thing. It would either go through probate through just a will, or it would go to the trust. The trust would then figure out how to disperse it based off the trust. Now, they could say, hey, we only want, in the trust, we could say they only want kid 1 to get 25% or certain assets, maybe just the house, and then kid 2 to get the rest of it. They could lay it out however they want, right? And they can so in the will, but again, it just depends on how the kids get it, right? And this gets more complex if you have, for example, John and Jane, who have, maybe John had a previous wife and other kids from that marriage, and now that gets a little bit more sticky, and we can address that in a different video. But just for simplicity's sake, this is really the benefit of having that trust. And again, there's some tax benefits, especially as we start getting into like the irrevocable trust and things like that. But really, it's important to have a trust. Now, if you a trust and a will, but if you only have few assets, so let's just say, real quick, that John and Jane, they have 2 kids. And let's just say they rented. Let's just say so they didn't own a house. They rented. Let's say they had, that $1.5 million in their 401k, labeled the kids as beneficiaries. Not a whole lot of assets otherwise, right? Then we could say, it's probably simple. This is probably a simple estate plan where we don't really need, there's not really a whole lot that's going to even go through probate. Maybe they had another IRA from Jane or something that had beneficiaries on it, or, another, maybe it was something like that, or, whatever, 50K there. So that would, if you had beneficiaries on that, that would go to, it would go to the beneficiaries. So if it's a simple estate there, then I think that would be the argument of why you wouldn't need a trust. But I think most of the time, I feel like folks, generally benefit from having a trust, protecting those assets, making sure that it goes to the right beneficiaries, because I have seen so many times in practice where families get fractured because things aren't laid out how they thought. And if there's no trust document or things like that put in place beforehand to lay that out, then it can get kind of hairy, especially, if you don't label beneficiaries appropriately. And then, that's when the arguing starts. People, I feel like, get very emotional once, death happens. And so people, I don't know, think very logically all of the time. It's more emotional. And sometimes that can get very, very sticky even when you have a trust and a will laid out very cleanly and clearly, things can get sticky. So if you don't have those documents, then it can get even worse. So hopefully that sheds some light on it. Again, very simple. There's a lot of nuances. So, as you look into that, there's definitely more that is, a part of the trust and the will and all that. But just for simplicity's sake, very high level, hopefully this helped and clear up some things for your own estate plan. Thanks for watching. We'll see you next time. Thanks.